I seek a lordship indulgence in mentioning item number 11. Lordship, I'm appearing for the state respondents.
Item number?
Yes. Item number 11.
Hearing.
Lordship, if this matter can be passed over for a day, Lordship, I have some personal difficulty today.
Matter was fixed yesterday.
Yes, it was fixed
You
yesterday,
asked
Lordship.
today.
I was not there.
The
So I have
matter
some
was fixed
personal
yesterday.
difficulty today.
You wanted the matter to be listed today. What is the matter about?
My lord, this is regarding challenging of filling up of 8 posts of the Mizoram junior grade of Mizoram Finance and Account Service. I am challenging filling up by way of direct recruitment only. It was filled up in that particular mode only.
Sure.
But our claim is that quota in the ratio of like for limited departmental examination as well as promotion has to be conducted, wherein we will be able to participate. That is our claim, and the writ petition was dismissed.
So you want it when?
Pass over for a day, Lordship.
My lord,
Tomorrow?
in that regard, I'm so sorry to say that I have to be out of station for medical reasons, my lord. I have to be, so it may be taken up on 30th next week, Wednesday. I'll be back on Tuesday.
The last day. Can we have it on 28? 27?
My lord, I'll be returning on 29th. I'm so sorry to say that, my lord.
Then we'll have it after the Diwali vacations.
Yes.
Let's have it sometime in
After 2 weeks, if it may come up, my lord.
4th of November. You have a division bench on 6th of November.
My lord.
At the request of the learned counsel appearing on behalf of the respondent,
State respondents.
state respondent, matters can be adjourned to be listed again on
My lord, 7th?
6th of November.
7th if possible, my lord.
No, here you are having on Wednesday a division bench normally.
Yes. Or my lord, in that case, 13th if possible, because I have one matter in the principal bench on 6th.
13th of November.
Yes. Yes, seek your lordship indulgence in making a mention of hearing item number 12, my lord. My lord, this matter wherein they have challenged the Mizoram Police Manual rules, and the matter was informed to the AG. The matter was supposed to be taken up by the AG, but with his approval, I'll be handing the matter. So if I may be given time to go through the file and at your lordship convenience and my learned friend, the matter may be fixed on some other date. I will be appearing in the matter and take up.
There's a challenge to the rules.
Yes, there is a challenge to the rules, but with the approval of the AG, I will be taking up the matter.
Okay, when do you want it?
My lord, this also if possible on 13th. 13th of November, my lord. if possible.
3030
1-3, my lord.
November.
Yes. This Wednesday.
At the request of the learned counsel for the state respondent, matters can be adjourned to be listed on 13th of November.
I am deeply obliged.
My lord, may I seek a lordship indulgence in respect of item number 13 of the hearing list, writ appeal number 6 of 2023. My lord, in this case, the writ appellants and the state respondents, they were having a attempt to make a settlement in this case. There's a talk between the writ appellants and the state officials. So if some time may be given,
This is what? Compromise?
yes, my lord. In fact, they were challenging the absorption
Between the state and the
officials, department officials.
what is the challenge here?
My lord, they were challenging the illegal absorption of the private respondents to the post of principal.
Then
And that is against the rules, my lord.
who has passed the judgment?
By the learned single judge, my lord. In fact, there is an amendment in the rules, in the relevant rules, which is oversighted by the learned single judge. So if 2 weeks time will be granted,
Okay. Done. The request of the learned counsel appearing on behalf of the appellant, matters can be adjourned listed after 4 weeks.
4 weeks.
Much obliged.
4 weeks, okay.
My lords, I beg to mention item 14 from the hearing column, my lord. If this matter may be taken up tomorrow, my lord.
What is this? You are
This
there
is-
for the,
This is a jail appeal, my lord. It's regarding.
you are the amicus?
I'm the amicus for the informant, my lord. In fact, the learned amicus curie is also having some personal difficulty today, my lord. So,
We appoint somebody else? If the amicus has a difficulty,
my lord, she has requested me that the matter may be taken up tomorrow, my lord.
and about, what about 15? Anybody is mentioning that? You're there.
On item 15, ma'am.
You want
If,
to do
if I can be granted some more time, my lord.
Huh?
If I can be granted some more time, my lord.
You are the amicus?
Sorry, my lord. Some more time, my lord. Yes, my lord, I'm from the amicus.
The request of the learned counsel is appearing on behalf of the respondent. Date 14th to the matter stands adjourned to be listed again. Twenty-eighth of October 2024. Two same at the request of the amicus appearing on behalf of the petitioner. I appearing on behalf of the appellant. Matters to be adjourned to be listed on 28/10/2024.
Obliged.
For motion, item number 1.
Item 1, 4, and 5 seems similar.
Lordship,
You are a respondent in item number 5.
yes, respondent, yes, in that case, we're respondents. However, there's a difference. What has been sought for in that PIL was that they are filing that PIL for the purpose of chasing out all those occupants. But the present case is for the purpose of, washing or making the provisions of the rule inoperative so far as the petitioners are concerned. Because the petitioners are the landowners. They have been granted their land way back in the year 1892, and they have been in occupation of the said land since then, till date, except for the portion of land which has been forcibly occupied by the Assam Rifles. Now, the challenge that has been made in this case is that though the state government had made recognition of their occupation and their pass, that is 333 of 1929, which was granted to their forefathers. Now, they had issued even land settlement certificates in respect of the portion which they have continued to occupy till date. But so far as the portion which the Assam Rifles have taken up and occupied since 1966, that has not been included in the LSC of the petitioners. In spite of that, the recognition was given by the authorities of the state government insofar as even that portion of land which is under the occupation of the Assam Rifles. And the petitioners have been asking for payment of rental compensation in respect of that portion, which is under occupation of the Assam Rifles. And even the chief, the ministers concerned, and even the chief minister of the state, they had recommended for payment of the rental to the petitioners to be paid by the Union Home Ministry. So in that view of the matter, what we have challenged is the 2002 Act, the provisions of 2002 Act, Section 3, 4, and 5, and the sketch map and the boundary description by which the petitioners' lands have been included without their knowledge, included in the occupied area of the Assam Rifles. Even the land which they have been occupying, the land which the petitioners themselves have been occupying, is within the land shown as the Assam Rifles occupied land, within the main barrack area. So, in that view of the matter, Your Lordship, unless a challenge is made so far as the illegal inclusion of the portion of land which has been granted to the petitioners from the sketch map and the boundary description, Your Lordship, there's a possibility of the petitioners being thrown out of their very land. If I take, Your Lordship, to the
Mr.
provision
Counsel,
of
Mr. Counsel, I'm new to out here, as you can see. First of all, just tell me, how is the land being allotted or granted out here in Mizoram?
initially, before the independence, it was under the authority of the superintendent of Lusai Hills. There are two superintendents, one in Aizawl and one in Lunglei. And the superintendent of Aizawl, he was the overall in charge of everything, the administration of the then Lusai Hills. Then that Lusai Hills came under the Mizo District Council. And when it came under the Mizo District Council, legislations were made by the then District Council, Mizo District Council, and on the basis of such such acts like House Site Act, Land and Revenue Act. House Site Act is of 1953, Land and Revenue Act is of 1956, and on that basis, allotment of sites were given. But in recognition of the allotment earlier made by the authority, that is the superintendent, conversions have been made in respect of those lands which were allotted and which were under occupation of the allottees. Now, that is the land which is covered by 333 of 1929. It is about 20 bighas in area. And
So your 333 of 1929
right,
was issued by the superintendent,
Superintendent,
of Science
yes.
at that point of time.
yes, Your Lordship.
Now, subsequently, some land was taken over by, you had initially 15 bighas of land,
Initially, we had about 20 bighas of land.
15, 1-5.
Yes. Now 15, more than 15 bighas have been taken away in the sense it has been under occupation of the Assam Rifles since 1966.
How much land was in occupation of Assam Rifles?
About 15 bighas.
15?
Your Lordship. Yes.
And how much was the total 333? How much area was there in past 333?
It is about 20 bighas.
20 bighas.
Yes.
So now you were in actual possession of around 5 bighas.
We are in actual possession of 3.62 bighas.
Now, out of that, the remaining land was taken away by the Assam Rifles forcibly.
Yes, yes.
And there were certain litigations fought by
Yes.
both you as well as the Assam Rifles.
Some rifles had initiated, they had filed a suit against us, in spite of the fact that land settlement certificate was issued to us, and though we had tried to make development by construction of our residential buildings within our allotted land, that, the Some Rifles made objection. They had posted their men and they demolished the structures. And in spite of that, we did not file a suit. They had in fact filed a suit in 1986, which was disposed of only in the year 2019.
The matter came up in second appeal before this court.
Yes, yes. After the matter has been taken up by the ADMJ and then to this honorable court, the matter was sent back to the trial court for proper decision on the basis of evidence. And after recording of evidence, the suit was dismissed.
Now, as per this act which you are challenging out here,
That's right.
that act states that any land which was under the occupation of the Assam Rifle
Yes, yes, Your Lordship.
would vest upon the state.
Yes. That has created the problem because it is not that the state did not recognize the title given to us, but that when they had passed this legislation, Your Lordship, if I take Your Lordships to page 111, 110 is the starting. It is known as Mizoram Restriction on Use of Transferred Land Act 2002. And it says that it shall come into force on such date as the state government may, by notification in the official gazette, appoint. And at E, under section 2E, a Lordship will see that transferred land has been defined as the land vacated by the Assam Rifles formations and handed over to the government in and around Aizawl.
Now, how does the Assam Rifles initially get right over the land?
Because it was during 1952, when they came here following the, being brought by the superintendents, they have come over here. They were allotted in the sense the gazette notification was made as regards the land actually occupied by them.
So they were allotted by
That
the
was
superintendent then.
There was no allotment as such. There was no allotment as such, but they had simply occupied a portion of land. And for the portion of land which they have occupied, a gazette notification was made way back in the year 1952 by the Assam government. And apart from that portion of land which they had occupied in 1952, they had extended the occupation in 1966 when there was disturbance in Mizoram.
So they themselves did it.
Yes, they themselves did.
Now, how did initially Assam Rifles enter into possession? Was it on the basis of some allotment or some
There was no allotment as
permission being
such.
granted?
No allotment as such, Your Lordship. They were not given any such allotment by the superintendent or by the authorities of the district council, even after independence.
Then how did they enter into the land? It is obviously
Yes, yes.
They
were-
paramilitary or military
They
force.
were being brought by the authorities, the superintendent, superintendent of Lusai Hills. They were being placed at different places within Aizawl. Some are here
How
in
did that happen? That is a very important aspect why I am saying so.
because at that point of time there was no law as such.
No, understood. There is a very reason. There is a particular reason why I am asking. You see, a land for giving effect to this particular provision of section 2E or 3 of this act which you are challenging,
Yes.
if there is an allotment being made or any right or permissive occupatory right being given to the Assam Rifles by the authority could have given only in respect to the land where the authority had a control. Now, they could not have given any other land beyond the land which the authority had a control. Just for example, any private person's lands cannot be given.
There's a number of such instances, Your Lordship, in fact,
Understood. Instances
because
are
of
there.
because of the
But legally
disturbance in Mizoram.
But legally speaking, if the possession of the land of the Assam Rifles was itself illegal,
Yes.
would section 2E or 3 come into play? That is my question.
Now,
Just for
the
example-
very purpose,
Just
Your
for
Lordship.
example, tomorrow the Assam Rifles comes over out here and takes over the land of the High Court. And
This,
tomorrow and thereafter they vacate it. Would the land belong to the
No,
belong
no.
to the government?
even all those lands under occupation of the Assam Rifles, they have never been allotted to them. Even this portion of land on which the petitioners have been allotted the, given the pass, it was never allotted to the Assam Rifles. There was no allotment as such.
So therefore, whether there can be a vesting upon the state if it is not being formally, because it would otherwise have vested if it was the government land. The government permitted these persons to be in occupation or any other land the government has a control, and as such has given the permission to Assam Rifles, okay, you occupy out here. And thereafter, when Assam Rifles leaves, okay, this land vests up again back to the government. That is permissible. But if it is a case where a person of a private citizen's land is concerned, if Assam Rifles tomorrow goes inside and occupies it, and then it vests upon the state, it will
Right,
have
right.
a far-reaching consequences. I hope you understand which I am
Yes,
trying to
yes.
convey.
Your Lordship, state being the authority, they have the eminent domain. In exercise of the eminent domain, they can allot lands to the individuals, to any other person.
But then
even-
also we had, at that point of time, we had it was a fundamental right.
Yes.
Still 300A came into the picture. 300A only made it a constitutional right. Earlier to that, Article 31 categorically provided that this was a fundamental right till it was struck down. So around 1956, it was still a fundamental right. So under such circumstances, this right could not have been taken away if it belonged to a private citizen.
That's true, that's true.
Yes, government, what do you have to say?
My lord, I am for respondent number 4, Union of India Council.
Government,
Then
let
if
us
I may
first
pro-
hear the government,
No,
state of Mizoram,
state of Mizoram.
you are the main person. Union will look into it first, later on. First, because he's challenged the provisions of a act. What do you have to say? Isn't it presupposed from these provisions of this act that the land which was allotted to the Assam Rifles when they were brought in the year 1956, and when they leave, the land will again vest back to the state. But can it be supposed that Assam Rifles usurps their authority and enters into some private land. And thereupon, when they go back, the land rests upon the state. It will have a far-reaching consequences. It will violate Article 300A. Isn't that your case,
Yes.
Mr. Counsel?
My lord, if I may permit it, the present writ petition could not be maintainable in its present form and style because now the item number 3 and 4 is related to that present case, and same cause of action between same person, between the same party could not be maintained by this
Item
court.
number 3 is by some other persons, not the petitioners. Are they the petitioners? No. Item number 4 is by some, it's a PIL filed by
Yes,
somebody.
it's a pile. Yeah.
Wherein they are made a respondent. But can in a PIL, being a respondent, seek a declaration that this provision is bad?
My
Tell
lord,
me. If it is
however,
possible, then I think it will be a new jurisprudence we may be setting out from the High Court bench.
however, my lord, the present petition petitioner intention is still remain the same because the Assam
But
Rifles
the
started.
petitioner is the respondent there in the PIL number 31.
Yes, they are also respondent number 53 and 54.
Understood. They are a respondent, but they cannot seek for a declaration that this particular provision is bad.
However, if I may permit it, my lord,
Yeah.
the Assam Rifles started occupied land in the year 1890. However, the present writ petitioner claim 1929. We already occupied the land before they have a land pass. Then we started to occupy
When
the
did
land,
Assam Rifles enter into the land?
my lord,
When did Assam Rifles enter into the land?
1890.
1890.
Yes, my lord. Then how at that time, my lord, we are under Assam government. Then as per Gazette 1952, Assam government of Assam in 1952, the possession of the land at Aizawl was given to First Assam Rifle, my lord. At that time, the government of Mizoram was not born. Then we are under Assam government, my lord. And that is why we are occupied the land as per the Gazette of the Assam, my lord. That is why forcible occupation of the land of the petitioner does not arise at all, my lord.
Now you have vacated.
Not yet, my lord.
We are not thinking in terms of the right of the Assam Rifles. We are thinking in terms of the land after the vacation, whether it has to be surrendered to the state government, even those portions which have been legally allotted to individuals, like the petitioner.
So as of now, Assam Rifles is in possession.
They are in possession, they have not vacated it as yet.
So they have
Continuously
not. So
possessed.
the operation of the act
That's
would
why
not
the
come
Assam
into play.
Rifles have not been impleaded as a proper party. They have been impleaded only as pro forma.
No, but as of now, if the Assam Rifles is what? The Deputy Inspector General.
Yes.
Understood. But if they have not vacated, then by operation of law,
Yes.
2E and 3 does not come into play.
Oh,
Yes, my lord.
Yes.
So that is one. And remaining portion of the land, which is around 3.5 bighas, which you are saying, is under your occupation.
Yes.
Now that is brought within the ambit of this act.
Yes. It has also been within the sketch map shown as the.
Where is the sketch map?
At page 121, Your Lordship.
Yes.
Page 121. The portion on the southeast portion close to Benghui area.
That's the forest area.
No, not forest area.
Okay, we do one thing we should notice today. Let us hear the other side, ask them to file the affidavit in the meantime.
Your Lordship.
Because as of now, they are in occupation. And is there any threat to your land, the remaining land?
Why we have filed this writ petition is that because there's a possibility of the some rifles being shifted to Zokasang within a short time.
We asked them to maintain a status quo. Status quo, you are Assam rifles. is
Because
still there.
if
No, my lord, if this, the present act should be applicable as and when the Assam rifle shifted
That
to
is
the
for
other
the
place
state of
only.
Assam, state of Mizoram.
But
to
we are
say.
still occupy the land, my lord.
No, you are in occupation.
Yes, my
So
lord.
you remain in occupation. Don't give up the land to the state.
as long as they are in occupation, this will have no application. This act will have no application. Because
But till you are in occupation, the
this
act will have no
transferred land,
application.
transferred
we need to
land-
decide that aspect.
My lord,
You are in occupation.
we are in occupation now.
So you remain in occupation.
Yes, my lord.
I'm not disturbing that. You remain in occupation.
Yes,
But because if you remain in occupation, then act would not apply.
yes, yes, right, my lord.
So therefore, maintain a status quo
Yeah.
as regards
Yes,
your possession.
yes.
You are in occupation, you remain
Yes.
in occupation.
Yes,
You're
my
not
lord.
disturbing your possession.
Yes, my lord.
But if the moment you are maintaining a status quo as regards your possession, that means you are not going to give it to the state. You don't want to give it to the state, I suppose, now. Issue notice making it returnable on. How much time to file your affidavits? Issue notice making it returnable on 20/11/2024. Ms. So-and-so appears on behalf of the respondent number 1, 2, and 3. And Mr. So-and-so appears on behalf of the respondent number 4. First, the said council duly accepts notice. First, extra copies of the writ petition be served upon them by tomorrow with the date. First, the case of the petitioner in brief is that their forefathers were granted settlement by the forefathers came to the Lusai Hills along with the Britishers in the year 1892. And thereupon, they continued to occupy the land at measuring 20 bighas. The superintendent of the Lusai Hills then had issued a formal allotment by pass number 333 of 1929 with a detailed boundary description. The petitioner thereupon, the forefather, the predecessor in interest of the petitioners thereupon, continued to occupy the said land. It is the further case of the petitioners that after the enactment of the after the enactment of the Lusai Hills District brackets House Site Act 1953, the petitioner number 1 had submitted an application on 16/2/1973 for necessary land holding pass / house pass for the entire plot of land covered by pass number 333 of 1929. However, a house pass number B5 of 1974 was issued in the name of the father of the petitioner number 1. Which admeasured 49,148 square feet. It is relevant to take note of that the said house pass so issued did not cover the entire area which was included in pass number 333 of 1929. Subsequent thereto, there was a partition amongst the petitioners. These are all the petitioners?
Yes.
Amongst the petitioners, whereby separate land settlement certificates were issued in the year 1986. It is the case of the petitioners that in the year 1966, the Assam Rifles forcibly entered into a part of the land belonging to the petitioners. Pursuant to the issuance of the land settlement certificates in the year 1986, the Assam Rifles had filed a suit being title suit number 8 of 1986, which was subsequently dismissed by an order dated, judgment and decree dated 12/12/2019, passed in title suit number 8 of 1986. Full stop. Next. The petitioner apprehends now that in view of the Mizoram bracket restriction on transferred lands bracket Act 2002, and more particularly section 2E and section 3, the land belonging to the petitioners would vest upon the state of Mizoram. Inasmuch as the entire portion of the land included in pass number 333 of 1929 have been brought within the ambit of the said enactment, and more particularly the map attached to the said act. It is under such circumstances the provisions of section 3, 4 and 5 of the Act of 2022 have been put to challenge. First, on that, the respondents, more particularly the counsel appearing on behalf of the respondent number 4 on instructions submits that the Assam Rifles presently is in occupation of the land, and as such there has been no vacation by the Assam Rifles. She further submits that submits on instructions that the land was allotted to the Assam Rifles by virtue of the enactment of
Gazette of Assam,
by the Gazette
1952.
Huh?
1952, my lord. Dated 8/8/1952.
On the basis of what is that document?
Gazette.
Assam,
Some Gazette.
Government of Assam.
The government
It's
of
a-
Assam has
Gazette
given what?
notification, my lord.
Show me that.
We already filed affidavit in PIL, my lord. That is
That's
item,
okay. Have a look at
item
it.
number 13.
We'll have it.
It was there.
Show me that document.
Takhan po yun ito. Kazukan yang eh.
Submitted that the entire land
Yes, my lord.
included in pass number 333 of 1929 was allotted to the Assam Rifles by the Deputy Commissioner Lusai Hills by way of a notification published on 8/8/1952. She therefore submits that the petitioners herein have no right whatsoever to challenge the enactment of 2002 or claim any right over the land in question. Ms. So-and-so, appearing on behalf of the state respondents, further submits that she would like to obtain instructions in the matter and file an affidavit. Taking into account the above, list this matter on or before the returnable date, the respondents herein, including the respondent number 4, are directed to bring on record their stand by filing their affidavits. Next, Mr. So-and-so, the learned senior counsel appearing on behalf of the petitioner submits that some interim protection may be provided to the petitioner. First, taking into account the submission made by learned counsel by so-and-so, the learned counsel appearing on behalf of the Assam Rifles, that's the respondent number 4, that the Assam Rifles is still in occupation of the land and there is no move at the present to vacate the land in question. This court is of the opinion that the provisions of Section 2E and Section 3 of the Act of 2002 would not be applicable for the present till the Assam Rifles vacates and hands over the possession. Accordingly, this court shall consider accordingly. I think this is enough. Do you need anything more?
Lordship was saying something about maintaining of the status quo.
Okay.
Because
Accordingly-
some rifles are not predictable.
Huh?
Some rifles are not predictable.
Beg your pardon?
Some rifles are not predictable. They are under the control of the Union Ministry, Home Ministry. So
But
if
if the
by
problem
tomorrow,
arises, you have not made the union party, na?
if by tomorrow
In fact,
they
strictly
vacate,
speaking, accordingly, this court directs that the possession, the status quo be maintained as regards possession by the parties till the next.
Your place.
For admission, item number 2.
Yes, Mr. Goswami.
My lord, in this case, I am appealing for the petitioner. My lord, here the petitioner has challenged the proceeding initiated under Lokayukta Act of Mizoram, my lord, and for being violative of section 19(1) and 2. Besides that, my lord, the petitioner has also challenged the constitutional validity of the Amendment Act of 2016. Now, my lord, recently I have come to learn, my lord, in fact, yesterday I could get hold of a notification which indicates, my lord.
Are you serious on the challenge to the amendments?
Yes, my lord.
Why?
Because, my lord, this act, my lord, under section 63 of Central Lokpal Act 2013, this act has been enacted, my lord. And the basic purpose, my lord, of the act to have a body corporate, my lord, to have a body of Lokayukta has been, my lord, done away with, my lord, the amendment. Now it's a sole non-judicial member chairman who is all in the, my lord, Lokayukta. Or even there is not a single member, not to speak of, my lord, judicial members. Non-judicial members are also not there, my lord. Only ground they are showing that due to paucity of fund, it may not be possible, and at times there may not be 2 members available. There could have been an interim arrangement, my lord. There could have been an arrangement to the effect that lack of quorum will not vitiate the proceedings. But they have completely done away with it, my lord. And in that way, my lord, they have created a law which is directly in conflict with the Lokpal Act 2013. Wherein, my lord, there has to be a body
Let's see
corporate.
the local law.
My
Is
lord,
that-
my lord,
Well, you're referring to which section?
my lord, for that, my lord, we have to go to the Lokpal Act of the Central Government of 2013
Yeah,
first,
that is
my
what
lord.
I'm looking
That I have annexed in my writ
No,
petition.
we have that
My lord,
Lokpal
before
Act.
that, my lord, yes, my lord, before that, my lord, may I have a small prayer, my lord? Since there are so many issues involved, I could not personally present today, my lord. My lord, may fix it on Friday, my lord. I will come to, I shall,
You could have taken a flight yesterday. Today you could have taken
my
a
lord,
flight.
my lord, today being my 20th marriage anniversary, my lord, I could not come, my lord. I'm so sorry for that. I will come on Thursday, my lord. My lord will take it up on Friday.
Clearly hear you.
My lord.
We can clearly hear you. Isn't it?
But virtual mode is not so persuasive, my lord. I feel it is not so persuasive. So I will try to persuade your lordship on Friday, my lord. I will come on Thursday, my lord.
We are trying to adapt what you call a digital friendly environment.
That is true, my lord. I also appreciate, my lord. But long persuasive matters, my
In
lord.
the luxury of the
Persuasiveness is.
party, whether you are there.
Well, let me come on Thursday, my lord. I will do it on Friday, my lord.
Okay, on Friday.
Friday, my lord. I'm deeply obliged. I'm deeply obliged.
Friday. Council appearing on behalf.
Deeply obliged.
Item number 3.
Yes, Mr. Muzamdar.
Your Lordship, I'm appearing on behalf of the state respondents. We are yet to submit a detailed
Yesterday, we, Lordships,
Mr.
made certain
Muzamdar, one
observations.
thing I
My,
tell you,
my,
sitting out here in Aizawl is a luxury. We get more time. And
my,
because of the time I could read through the brief.
my.
Your
I'm
case
so
up
great.
there
I'm
is
so grateful to your Lordship.
two.
My,
First, the state of Mizoram is not getting the amount, the minimum guaranteed revenue or whatever may be, is not being paid by some of the Sumit online and all. They are not paying. There was a particular period for that.
my,
And the second is, how can they use a paper lottery digitally? It is a
My-
violation to the Ministry of Home Affairs directives.
also the act and the rules. My.
Does not say anything.
Act is very clear.
Act does not say anything.
My lord, Act separates online and paper lottery.
Okay.
Now, when
Mr. Mazumdar, very good. What is an online lottery? Let us also be enlightened by you.
well, first of all, if your lordship permits me, I'll take.
How does an online lottery operate, Mr. Mazumdar?
My lord, I'm not an expert on this. I can simply
Absolutely,
say,
you have to. You have to be expert on this. You cannot come up with this and without
Madam.
knowing the intricacies involved
Madam.
in an online and a paper lottery.
My
Here,
lord, the-
what they
my
are
lord-
using, they
My
are
lord.
using the difference between online and paper is this. A
My
paper
lord.
lottery, there are numbers,
my lord,
specific numbers. Some particular numbers are there. You can choose one of the numbers.
my lord,
Online lottery, by a computer generated,
yes, my lord,
a number is given,
my lord,
and that number you in both the cases, in this case you can enroll yourself, you have to register yourself
my lord,
with your email or everything, and then this online number which is being given to you is you accept it
My
and
lord.
it gets feedback in the computer system, and that is why
My
you
lord.
have the STQH or whatever may be, that particular certification is required there to have a central server,
central server,
because
yes,
that is why it is required. On the other hand, a paper lottery,
my lord,
either you can sell it with the sale of the papers, or
yes,
what they have done out here is that they are selling the same paper lottery on an online by giving you a particular, you can choose various numbers out there. And on the basis of that. Now, how are you affected? Taking into account can you buy in a SAM this paper lottery? No. Can a person in Mizoram purchase it? No. Because for the purpose of purchasing this particular lottery, you need to get out there, show your residency to be only at Maharashtra, Sikkim and Goa.
yes,
Outside that, you cannot purchase it if you are
paper
not
lottery,
within the
paper
boundary.
lottery,
And
paper
this is
lottery,
being
yes,
verified on the
My-
basis of particular documents of identity being filed at the time of registration. So how are you aggrieved? Your aggrieved may be one, if it was a person coming from Maharashtra, a person coming from Goa, or coming from Sikkim, they come up out here, very well. But how are you aggrieved? One agreement, there might be one thing you may be aggrieved of.
my lord,
Being a citizen out here of Mizoram, the state of Mizoram is not taking the certain money which they are likely to take. The minimum guaranteed reserve,
revenue,
they have
revenue,
exempted many people out there. For that you may be aggrieved, but not on the other aspect. You need to find somebody from Maharashtra.
for one part, for one part. So for the other part, if I am agreed, my lordship, I agree with the
Otherwise, all these other things have nothing out there, because Mr. Datta's client may have stated out there how are they aggrieved and all this is not, because you were also informed. You see, the difference between an online lottery and an offline and a paper lottery is, in a paper lottery, here if you see, I think the regulations out here is 24, if I'm not wrong, of the rules of
Rules.
Mizoram, 24. It is to be done under the aegis of the director of lottery or somebody. It is
My
to be
lord,
done.
my lord, yes,
It is they who is going to do. On the
Desi-
other hand, in
designated
online,
authority.
it is been done only by the computer. That is the
Yeah.
central server who will do it.
my lord, here only one submission I'll make. Your lordship is absolutely correct, man. This server has to be under the
Only
control
question,
of,
Mr. Mujumdar, is
My
I
lord.
need to only ask the state government, are they getting the minimum guaranteed reserve?
that your lordship will 100% ask me. Only one aspect on the other point where your lordship is saying that the paper lottery they are selling through online, but it's paper lottery. Well, here only another aspect is there, my lord.
Why
The
haven't you
act
approached? But Mr. Mazumdar, why haven't you approached the union? The union, the
I mean,
Ministry of
yesterday-
Home Affairs. Why haven't you approached them?
My lord, your lordship is right. To some extent, my lord, there
See,
is
why so I'm saying so?
my lord.
The person out there in Kerala also have this.
My lord.
They approach the Ministry of Home Affairs, and then on the
Right.
basis of the direction by the Ministry of Home Affairs strictly,
My lord.
Kerala has come up with a notification that you cannot sell digitally.
My lord, if your lordship permits me, I will show an answer to a query made in the parliament recently, my lord. I think my learned friend, lordship, may just allow me to, this has happened in 2-3 states, and after complaints were made, the state government, in the parliament, my lord, the government of India has made it very clear that it is not permissible. May I read that, my lord? My learned friend will hand over a copy of that. Listen.
Yes.
There is on 2nd of October 2022, my lordship will be decision.
Yes.
My lord, on the top, my lord, to be answered on the 2nd of August 2022, 7, etc. My lord, there are questions with Ministry of Home Affairs, please to state. A, B, C, lordship may skip. C and D are important, my lord. Whether as per the MHA letter, lordship has got, my lord.
Where? You have given which letter?
Letter, it's Government of India, Ministry of Home Affairs, Lok Sabha, unstarred question number 2613. My lord, if you,
No, we have not
Well-
got those. We have been only given one letter of the Directorate of Small Savings and Lotteries, Government of Goa, and the other is by the
Yeah.
Calcutta High Court, one is by the Supreme Court.
in fact, my lord, in the reply we propose to file to the application challenging maintainability, we are annexing that document as Annexure A, page 14
Of?
of the reply. But my lord, we are yet to file. We have prepared the reply. We are filing it today or tomorrow. We will file it. Annexure A is page 14. We have annexed that document. I'm just reading. Lord, kindly give me just 1 minute. I'm reading it. It says, my lord, the question was, there are two important questions. One is whether as per the MHA letter dated 22/1/2019, features of online and paper lotteries cannot be combined in one lottery, but today, paper lottery distributors of Punjab, Sikkim, Nagaland, etc., and their associate concerns are selling paper lottery tickets through websites accepting payment online and WhatsApp application on mobile and last minute question B. If so, whether the permission for sale of paper lotteries through online mode is given to the organizing states to allow their distributors by MHA, and if not, action that shall be taken by MHA in this regard. Now, while answering this, my lord,
Who has answered this?
my lord, the Minister of State in the Ministry of Home Affairs, Sri Nityananda Rai.
Of the union.
My lord.
Yeah. In the parliament.
Well, yes, my lord.
Then?
The answer is like this, my lord. Ministry of Home Affairs has issued directions on 2/8/2011 under Section 10 of the Lotteries Regulation Act 1998, stating that it is the responsibility of the state governments to ensure compliance with the provisions of the Lottery Regulation Act 1998 and the Lotteries Regulation Rules 2010 in letter and spirit. Further, directions have been issued on 18/7/2018 to all the lottery running states to have their software, hardware used for online lottery certified by Standardization, Testing and Quality Certification Directorate (STQC) to ensure integrity of the hardware software used for operation of online lottery. Thereafter, instructions have been issued on 22/1/2019 to all lottery running states that a lottery combining features of online and paper lotteries is not in accordance with the Lottery Regulation Rule 2010, and therefore the same be stopped forthwith in case already launched by any of the lottery organizing state governments. Taking into cognizance the responsibility assigned to lottery organizing states under the Lottery Regulation Rule 2010, the complaints received in ministry are forwarded to the concerned lottery organizing states for appropriate action. Accordingly, complaints regarding selling of paper lottery through website, mobile apps have been referred to the state government of Punjab, Sikkim and Nagaland. Government of Punjab has informed that they have already prohibited the sale of computerized and online lotteries and not authorized any distributor to sell the lottery tickets in online mode. Government of Sikkim has informed that state is not aware of selling of paper lottery ticket through either website or WhatsApp application on mobile. The government of Nagaland has informed that the state government has neither given any permission to its distributor for sale of paper lotteries through online mode, nor the distributor of Nagaland state lotteries have sold or selling the tickets through website accepting payment online and through WhatsApp application on mobile. So this is the position, my lord. My lord, here as your lord, I am grateful to your lordship, my lord. The lordship has gone through the entire thing. My lord, what I am saying is, my lord, the act says, my lord, the act says there has to be conduct has to be lottery, entire lottery operation has to be conducted by the state government. No private party can do it. And I show from the rules, my lord, there has to be a portal which will be under the control of the central government, state government. Now, in this case, they are allowing the private party to have their own portal. So what they are doing, nobody knows. The state has got no control. My submission before the lordship is, my lord,
How
when
are you
the act is
concerned? How are you concerned?
my lord, here,
Your
here
locus is the question. How are you concerned to that effect?
my lord, there are two aspects. Your lordship indicated yesterday
Yes,
that
because
one.
have you thought about how much should be the cost? 5 crores?
My lord, yes, yesterday your lordship said 5 crores, my lord. I think that will be appropriate.
Appropriate.
Because-
There's a cost of 5 crores. There's a cost of 5 crores. You deposit the 5 crores, then we issue further proceed.
My lord, so far as the second part is
You
concerned,
deposit the
NTR,
5
your
crores by
lordship.
tomorrow. 5
My lord,
crores.
so far as the second part is concerned about the MGR, your lordship has already
Entertain the
seen.
PI subject to payment of 5 crores.
My lord, I am a private individual social worker. I have got-
Not a social worker. I would have understood a person from
My lord.
Maharashtra coming, a person from Sikkim coming, anybody from there who is otherwise affected. Your locus
My-
is the main problem. How are you
My-
concerned with anything except to the fact that
My
the
lord.
state is not getting the whatever amount?
My lord, that part, as your lordship are
You,
lordships
why
are
haven't
satisfied
they
that.
approached the ministry of, because that is why Nagaland, Punjab and all these places, Sikkim, they have
My
approached.
lord,
That is why this has happened. If you have approached, this should have been much
They have
better
approached.
than going ahead with all these times. This
my lord,
PIL.
lordship will permit me to approach the central government. I will approach the central government.
We close the PIL, giving you the liberty to approach the ministry. That is the only way. This is not the forum by which. Or else, deposit the 5 crores. Another judge will look into it as to whether
Lord,
that has to be appropriate.
My lord, yesterday I had gone through the petition. There are some more pleadings are required as your lordship indicated. Lordship will give me liberty. I'll approach the central government first.
Online lottery,
My lord,
online
my lord, I'll
lottery
approach the
in
cent-
Assam, in India, is
My
done
lord.
by Lotto.
my-
Lotto India is the online lottery. There, how do you do it is, you have to register yourself. Once you register, then you enter into the website, you are automatically given certain numbers by the computer.
my lord.
No role of anybody else. Once you accept those numbers, you say yes to these numbers, it is fed to the server. So there might be,
Fed.
just for example, there are 5 numbers which are given. 5, 6, 7, 8, 9, 10, 11. These 5, 6, 7, 8, 9, 10 may be there to you as well as to Mr. Dutta also, if both of you are playing. And these numbers will be fed in the server, and on the basis of that, the moment you win it, it will be given to you in the email. Informed to you in the email that you have won it. And you get it for the last 30 days, which are the numbers which have won in this. On the other hand, the paper lotteries, what are there? The numbers are being given. You can choose which are the numbers which are being given. You choose, and automatically on the basis of that, the paper lottery will be, which you have got it. This will automatically come to you. And that number, that lottery has to be shown for the purpose of claiming the prize, which is not there in online. So
Yes.
here you have the control, or any human interface is there in a paper, which is not there in online.
Yes.
So here what they are doing it is trying to make it paperless courts.
My lord, apparently, well, what your lordships are suggesting, my lord, apparently it appears to be quite innocuous way of functioning. But inside what is going on actually, but it's very difficult to give the exact figures and what is actually happening. But fact remains
But I
that
think
all other
what
states,
you,
three
if you are
states, my
so
lord,
interested, why don't you move the Ministry of Home Affairs?
my lord,
That look here,
my
this
lord,
is
as
what
your
is
lordships,
happening. You have
my lord,
already
as your
taken
lordships are
action
indicating,
because I tell you, that is why I'm saying
my lord,
Kerala
my
has
lord,
passed an order. Specifically, you cannot
my
sell
lord,
it digitally. They passed an
my
order.
lord, I should have, your lordship,
You should approach the
my
Ministry
lord,
of
your
Home.
lordship, well, if the lordship gives me that liberty, I'll approach. But only one submission I'll make subject to your lordship's consideration, my lord. In the SP Gupta's case, my lord, this ultimately the Honorable Supreme Court has said that if in this kind of situation when a specific person or a specific determined class of persons are not affected, but public injury is caused, anybody can come, but it says that having interest in the proceeding. Now, what is
You
the
have no
meaning of
interest.
having
Your
interest in the proceeding?
interest would be only for the state government to say that yes, I have got
My,
the money. And if you see the amounts which have been reflected in the RTI reply, they say that we have
my,
received these amounts. Only for Sumit,
they
where
have,
there was a termination, they did not go ahead with that particular lottery.
yes.
For that, then also they did not pay. That is maybe an issue. But the state government is a benevolent government like our state of Assam, where you represent as the additional agent.
That is what I was saying. But by this benevolence, they are actually affecting the people. State exchequer is being affected. That is, your lordship will give me a liberty. I'll approach first the central government, then I'll come to your lordships again, my lord.
I think that is a better option. Once you
My
approach
lord.
the central government, it is okay.
And my lord, here, my lord, I'm sure, my lord, will be able to give more details about the menace of operating or selling paper lottery through online. But there are certain things which were not incorporated in the
Because
petition,
as of now,
my lord.
there is no decision of any courts to the
No, my lord.
effect that paper lottery
In
cannot be
fact,
sold digitally.
my lord, in fact, there is one instance. In the Arunachal Pradesh also, similar thing was done. It was online, but they are trying to sell it through website. Then there was a challenge through a PIL. PIL was entered. I have annexed a copy of that, my lord. PIL was entered, but in between the state government itself had issued directions not to do it in this way.
No, it's
I have
okay.
annexed the order, my lord.
But as of now, there is
But there
no
is no order.
judgment on the point as to
My
whether
lord,
paper lottery can be sold digitally.
my lord, I was thinking that your lordship will admit and pass an order so that this will be a law for future.
So I can very well pass a law. I am very in favor of selling it digitally, which may go against you even
then it
later.
will,
You can't approach because
then it will
we
go
are
against me,
we
my
are
lord.
in the digital world. Everything you get a railway ticket out there digitally. Everything you are getting digitally. You
No,
don't
my
need to
lord,
carry a
my,
single penny
my
nowadays in
lord,
your pocket.
my lord, there is one small catch, my lord. When a authority or railways sell railway tickets through online, we save paper, we save environment. But here, what is happening is, my lord, in the garb of selling paper lottery through online, they are doing certain illegalities where it's very difficult to point out, my lord, specifically. There are, my lord. Yesterday, we had a lot of deliberation with my
Mr.
learned junior,
Muzumdar,
my lord. Certain things,
your line of the case, which
my
you
lord,
have built up,
my
even
lord,
your RTI applications,
my
are
lord.
not in that manner which have been developed
My lord, I
to that
agree. My lord,
effect
I
how
agree.
much loss is your case is then look
My lord.
here. If it is a case where 50% that the 1,000 tickets are to be actually being done, but they don't know the state of Mizoram is not in a position to know how much actually is being sold and to
Exactly, my
get the
lord.
minimum receipt.
Exactly, my
But
lord.
that
This
is not
is
how
the
you
issue.
developed your case.
My lord, I admit, my lord, these materials are not eligible. I had gone through this line by line yesterday, my lord. That is why either your lordship will permit me to file a detailed affidavit or your lordship will give me the liberty to approve the central government. I'll approve the central government first with all the details and then come back to your lordships again, madam.
Yes, government, what do you have to say now?
Your Lordship, we have actually,
Are you getting the money from this respond number 8 or not?
Your Lordship, I will have to seek instructions on
Huh?
that regard.
This is
I
an
will have
old
to.
matter, 2024 PI.
Yes, Your Lordship. Yes, Your Lordship. But however, we have actually made some queries to the state respondents, and
There are simply two queries. One is whether you are getting the amount or not from these people.
yes, Your Lordship, I will have to seek
If
further
you are
instructions.
getting the amount, matter is over.
Yes, Your Lordship.
Otherwise, this we are not going to question on the other aspect. We for this petition. I would have understood if it is done by anybody else because those people are being duped. Today, if the petitioner is doing it, the petitioner comes up. Petitioner has made out some form of a case to the effect that by doing this online digitally, you are not in a position to know actually how much
Yes, Your
tickets are being sold.
Yes, Your Lordship.
As per the agreement, you are entitled to a particular amount and the minimum guaranteed reserve is this amount.
Yes,
Revenue
Lordship.
is this. Petitioner's case is that you are not going to get it unless you have a control.
Yes, Your Lordship.
Your only answer is yes or no. Do you have a control? Don't have a control. Matters.
Your Lordship, on that regard, I will still have to seek instructions from the state respondents.
How long?
Your Lordship, by
It's very
tomorrow.
nearby. Your office is very nearby. Aizawl is a small place.
Your Lordship, I will be, by tomorrow, I'll be able to
2
get the
o'clock?
instructions.
2 o'clock. 2 o'clock.
Tomorrow.
We'll get the
2 o'clock, 2 o'clock, yes, Your Lordship.
Huh?
Yes, Your Lordship.
Yes, 2 o'clock. Only that we get it. It's the whether they are getting the minimum, the amounts. That's all, nothing more than that, man. And if they are getting the amount, then obviously you have to then approach the Ministry of Home Affairs. That's it. I think that is a better way how it is doing, not by you, by anybody else. I think better.
If I
We'll have it at 2, Mr. Doctor. We'll have it at 2.
Item number 4 and 5.
May it please your lordship. My lord, I was directed to file a detailed affidavit by order dated 6/9/2024, my lord. However, one RTI response is awaited by me, and I seek 3 more weeks' time to file my affidavit, my lord.
But they are cancelling some of the passes, huh?
Yes,
Yes,
those
my lord.
those
We have
were surrendered passes, my lord.
21 people are left,
Yes, my lord.
as per your affidavit.
Yes, my lord. However, my lord, in the last court date, even I was granted some time to file detailed affidavit and to produce some documents.
No, last time when Chief Justice came,
Yes, my lord.
he passed a specific order. And so how is it possible
Yes.
that these passes have been issued prior to even the creation of
86.
Mizoram state by the Mizoram government,
Yes.
even before the Union Territory was created. So there you have filed an affidavit, you have issued show cause notice to many people. Somebody has already surrendered the passes
yes.
and some have submitted the reply.
Yes,
Then you are
ma'am.
taking steps in that regard. You are to explain why you have not explained.
Yes, my lord. With that particular question of the Chief Justice, I have sought for an RTI as to my house pass, which was issued back in the year 1971, has come into.
Do you want to file an affidavit?
Yes, my lord.
Yes, Mr. Malhotra, what do you have to say? You are there for whom?
I'm appearing the next item. Item 5, Your Worship.
You are the PL.
PIL, Your Worship. Your Worship, in this matter, the PIL, the earlier stance of the state respondents was they have issued show cause notices to the landowners. And after submitting of the replies, 13 persons who have surrendered their passes have been cancelled. But the balance action has still to be taken by the state respondent on the basis of their replies.
Are these passes issued fraudulently? Is that your case?
That is our case is that the Assam Rifles has been in occupation since 52, or in fact prior to 52, but all these passes were issued subsequent to 52. So how could these passes have been issued to individuals when the Assam Rifles was already in occupation of the land? And the state respondents also issued show cause notices. Replies have been submitted. But now the stand taken by the state respondents, they have taken a direct U-turn. Now in the latest meeting, they have come to a decision that they will be transferred to some other alternative plots of land.
No, that is what I could see in one of the affidavits.
Yes.
Which they say that they may be, the passes would be cancelled, but they would be allotted some other.
Relocate them, yes, Madam.
So you have now, earlier
Now,
they
does the state has any land policy?
that is what you are, what are the steps taken by them regarding alternative allotment, and what is the status
And what is
report?
the provision out here for granting allotment or settlement or by way of these passes? What is the provision? Or is it by only on executive instructions?
Early on, it was under the 56 Act, Land and Revenue Act, 1956.
Let us have a look at it. No. This will be Mizo Act.
56.
Mr. Malhotra, what was the provision prior to 56? Did you follow the Assam 1886? Or was it because of because in places like Arunachal Pradesh, they used to follow the Frontier Act. They used to have the Frontier Act. What was followed out here?
I'm not very sure regarding that prior to 56, but I know that as a fact, the superintendent of the Lushai Hills, they were competent to allot land to individuals.
Now that is okay.
Yes.
But what is the provision? There has to be an authority somehow, because you see, 1886, this was a part of Assam.
Yeah, before that, Yajub, the chief of the village was the authority.
No, understood, but how? An authority can be only on the basis of something. Just for example, that is why I'm saying, in the case of, if these are frontier areas at that point of time, in Arunachal Pradesh, you have this, the Frontier Act, by which how the land is to go and being transferred out there.
Yes.
These are being duly taken care of. Now, in Mizoram, was there any codified law, or was it followed on the basis of, it couldn't have been customary, taking into account that the superintendent Lusa Hills was given the authority to do so. Either there would have been some executive instructions to the
if
effect.
I'm not mistaken,
And Madam has produced one document in that affidavit. You were there, no? For Assam Rifles? Yes. She produced the document to the effect where the DC, DC Lusai Hills. There was a DC of Lusai Hills
superintendent.
at that point of time.
Superintendent.
Let us see, it's Mizo here. এখানে কি উড়ালেছে? বিল না থাকে নাকি?
라인은 substitute for administrator. masih apa macam district council and auto council. Area kan kalau masih village lalu station area Abolition of chieftains rights. Masih station.
So it is after the rules were made.
Yes.
Then the question came about the land settlement certificates.
Yes.
Earlier it was a pass.
I don't know.
There was a settlement that then also in the 1956 Act also.
Yes.
You have the settlement. There is two types of
Yes.
rights.
Yes.
One is a settlement holder and the other is a pass holder.
Pass.
So the settlement holder is, I think, yearly basis. Pass holder.
Password.
Whereas the settlement has more rights. It's a heritable right and
Ownership right.
Okay. And then comes the certificates to be issued. Now, what is the basis on which the Assam Rifles got the right in 1952?
According to the affidavit filed by the state, they are saying that they have no ownership rights over the land. They are
Who?
just occupying it. The Assam Rifles. The Assam Rifles have been in occupation of the land occupied by them, but they have no rights over the land.
No, if they are in occupation, that is what I was asking the
Yes.
senior counsel when he was taking up item number 1. If they were in occupation, what is the basis of after all, Assam Rifles is a state authority.
Yeah.
It's a paramilitary force out there. So if they are going to occupy a particular area of any area,
Yes.
that has to be based on some authority.
They were stationed there by the state authorities. That is for sure. I mean, they did not just come in and force their way in. The state authorities let them occupy the land. But now
So the moment the state authority,
Yes.
the state authority therefore could direct them to occupy the land subject to the state having the power.
Yes, there's. Your Worship will see
And,
Section 8 of the 56 Act. according to this, all the land,
All the land belongs to whom?
the state,
Where? Section
56 Act,
Power
section,
of the administrator.
yes.
In the case of any land over which no person has the right of use or occupancy under this act, or which is under use of
So all the land vests with the state, and the state has the power to make allotment to vacant land.
No. That is dependent upon a person having no right.
Yes, Your Worship.
But if there is a person who has a right,
Yes, Your Worship.
right of use or occupancy,
So in our case, all the passes were issued subsequent to 52, after the land was occupied by the Assam Rifles. So our stand is that it was not vacant land. If it was not vacant land, how could the private respondents have been issued passes by the state? Because the state can allot passes to individuals only over vacant land. Now the land,
no, but
Being-
vacant land, where is the question of vacant land? Because if you see, it is not a vacant land. In the case of any land over which no person has right of use or occupancy,
yes.
so there has to be a right of use or occupancy.
So
One.
the right of use or
Occupancy.
occupancy devolved upon the private respondents only when their passes were issued.
No. Prior to that,
Yes.
if there was a no right of use or occupancy given even to the Assam Rifles, then in that regard, wouldn't that give a right to issue the pass? It doesn't say about the vacant land.
Yeah. Power
It
of the
doesn't say,
administrator over
because
vacant.
section 8 does not mention about a vacant land. It says about the creation of a right which is not there. Then the state government can. In fact, by virtue of this act,
Yes.
the lands, all lands where a person has no pre-existing right, stood vested upon the Lusa Hills. I think this was the Lusa Hills, no, at that point of time. Mizo. It happens on the vested upon the administrator. So it is not the question of whether it is vacant land or not vacant land. If there is no creation of a right, the pass holder can be issued to anybody by the administrator.
That is your worship, but then the procedure has to be followed. But now, according to our interpretation of Section 8, if the land is occupied by someone,
No.
then the land
There-
cannot be
no,
allotted.
There is no question of occupying. But anybody, a trespasser may occupy. No quarrel with
But
that.
your worship, it is not the case of the respondents that the Assam Rifles is trespassing upon their lands.
No. I'm not on that.
Yeah.
I'm saying a trespasser may also occupy. Anybody can occupy. But occupation is not a right. There has to be a right to occupy,
Yes,
which
yeah.
is another aspect of the matter, which is a conferment of a right either on the basis of existing customary law rights which were there, or the conferment of right by any authority empowered to do so.
Well, your worship, now I feel the dispute between the landowners and the Assam Rifles now, they claim that they have been issued land settlement certificates, land passes by the state authorities. Assam Rifles say that we have been there since 1952.
No.
Before
Being
that-
occupied, therefore the question is,
Yes.
what is the authority on which the Assam Rifles has? Now they say about a 52 notification. Now can the 52 notification is given under what authority? There has to be an authority.
Your worship, that is for them to clarify now. Under
Then
what authority
if
they
I
have been
again-
occupying the land.
If I again come back on 19th of November, which I don't think so, I would have definitely put that question.
Yeah.
But the question out here is, how is it possible?
Yeah, I understand. How did the Assam Rifles come into occupation of the land the first
Yes,
instance?
how?
That-
What is the basis? There has to be a power.
The records will be with them, Your worship. But now, Your worship, the main concern of the petitioner in this PIL is that steps have been taken to shift the Assam Rifles to another location. And now the land which is occupied by them is prime property in the heart of the city.
And we are afraid that once they're shifted out, this prime land will be occupied by individuals,
By the?
by the individuals.
No, that will be the best upon the government in view of the 56, the 2002 Act,
But
12 Act. Or
that,
whatever.
that is there, but whether the state respondents will be able to apply that act. And now, Your Worship, in the latest meeting, now they have changed their
So,
stance.
Malhotra, we are in the judicial side, that is for the political ideas to follow. What is to be done?
Yeah, now they are saying
But the
that
question is, the government has to satisfy this court as to how there has been a creation of a right upon Assam Rifles in 1952. How? There has to be some power somehow. You can't create a DC. If the DC has done it, yes. Can be traced to 1886 Assam Land and Revenue Regulation. Somewhere, somehow, it has to be done. Because unless there is a right, therefore here you see, it is not a right of use or occupancy. The word is right of use or occupancy, not a question of person occupying, not a question of a land being vacant or immaterial. Whether that person has a right of occupying, therefore there is a creation of a right.
if Your Lordship will see the affidavit filed by the state, in the affidavit filed by the state,
No, I've seen
I
that
mean-
affidavit file. They are very generous,
Yeah,
benevolent state.
now the previous government was quite strict. Now the present government has become very lenient. They're going to allot. So anyway, Your Lordship, at least let them come up with a status report. What are the steps taken by them in pursuance of the meeting, whereby they have already stated that they're going to make alternative allotment to the land.
No, let us first get the instructions from the state as to under what authority
Assam Rifles
they
is in
have
occupation.
granted, under what provision of law they have granted any right upon Assam Rifles.
Your Lordship, if I may take a
Not on
lordship-
the basis of a notification, which madam is going to show, of the 52, no. It has to be on the basis of something.
Your Lordship, in the affidavit filed by the state on 19th of June.
Katsayang ako. Katsayang karon ako. Katsayang tani nga sayang. Also kasi doon, no, also kasi yung asya may ang karlinen. Apart of isang kan state, ang doon tidang naman nila. So, hiya na ron kung pang kakalungan. So, yun doon kasi. My Lord, if I may, as per my humble understanding, my Lord, the Assam Rifle was permitted to occupy the land as per the Assam Gazette in the year 1952. At that time, Mizoram were a part of Assam. Then thereafter, we are a state. However, unless and until that Gazette has been reversed or cancelled by the state respondent, we are still have existing right, as per my understanding. In the meantime, as
But
per
madam,
the
tell me one thing.
yeah.
Who authorized you to remain has to be on the basis of some power being conferred by a statute. It cannot be on thin air. It cannot be in vacuum. The power is, everybody has a power to exercise when it is being conferred on the basis of an enactment. Somehow. It cannot be we are still in the year of the kingdom of the kings
Yes, my
out
lord.
there who can very well say.
Now, my lord, as per my understanding, the state government themselves accepted that as per this Act 2022.
This notification is issued under what provision? It doesn't show anything. Yet the DC just has given it. And then not also it is merely an allotment, not even an allotment, a right to occupy. What is this right to occupy? Both the cases, one order. After hearing the learned counsels appearing on Mr. So-and-so, who is appearing for the private respondents in the PIL? You are there, na?
Yes, my lord.
Mr. So-and-so appearing on behalf of the private respondent submits that he requires 3 weeks' time to file an affidavit in terms with the order passed by this court on
6/9/2024.
on 6/9/2024. It is also seen that the state respondents have already filed the affidavit in pursuance thereto. Ms. So-and-so appearing on behalf of the Assam Rifles submits that that Assam Rifles have been authorized by the DC, the then DC, Lusai Hills, in the year 1952, to occupy the land. However, from the pleadings as well as the submissions so made by the learned counsels appearing on behalf of the parties in both the proceedings, there is no mention as to how, on what basis the DC, Lusai Hills, had the authority to confer such right upon Assam Rifles. Full stop. This aspect needs a clarification, inasmuch as a creation of the right has to be based upon a statute. The state respondents as well as the Assam Rifles are given the liberty are directed to bring on record their stand by making appropriate, by filing affidavits clarifying the said aspect.
Lordship,
Matter again
I'm appearing on behalf of respondents 49 to 53.
You give it out there so they know how to print it. The thing. We just put their names. Okay. At least the matter. When do you want it? We fix your matter, Mr. Senior Counsel. We fixed your matter when?
After 4 weeks.
That item number.
After 4 weeks. It was after 4
No,
weeks.
we fixed the date. 20, huh? 20. List the matter again on 20/11/2024.
Obliged.
Your Lordship, I would like to make a mention regarding PL number 3.
Yes, PL, what is that?
Yes, Your Lordship. I actually just got the instruction regarding whether the state receives the minimum guaranteed revenue, and the answer is yes, Your Lordship, as per the agreement.
Huh?
The answer is yes, Your Lordship, that they do receive the minimum guaranteed revenue.
Are you getting the money?
Yes, Your Lordship.
You're getting the money?
Yes, Your Lordship.
You're satisfied with the respondents, private respondents? Are you satisfied? Because there is an allegation to the effect that say out of 6,000, they are actually showing to you around 6,000 tickets are being printed or sold through online, but in actuality, there's a 10,000 tickets which are being actually sold, but you are not getting the anywhere. Isn't that, Mr. Mozumdar, your submission?
My lord.
What do you have to say on that?
So unless it is on paper and we can prove it, I mean, unless the petitioners
They
can,
have given some calculation in a very difficult time, even for me to understand.
but at the same time, Your Lordship, the maintainability is also in question about whether it should be a PIL at all.
This is the problem. In PIL, maintainability is changed and then the real issue is not gone into because of this money.
Well, that is also because of the fact that, my lord, he is seeking an enforcement of the contract entered into between the state and the distributors. That whether he can go do that in a PIL. My lord,
Mr. Dotto, don't improve the case of Mr. Mojumdar. Because the moment you are saying that, the question comes about the public revenue.
No, my lord,
The moment the question of
query
public
that you-
revenue comes in, and anybody out there who is, if you are saying that you cannot look into that, then why not? If the state
No,
is
my lord,
not getting the amount for which this is obviously it is something like
My lord,
liquor,
your
where it
lordship's
is
query, my lord, your lordship's
extra
query
commercial.
was whether the state is getting MGR as per the agreements or not. My lord, the answer is yes. I
No,
have
the
been
answer is yes, provided you are saying it. But it is not on affidavit. Neither you have said a single word to that effect. Neither Sumit
that-
or everybody has been saying, because here he has brings out one aspect of the matter. In fact, not bringing the other aspect would have been better. Instead of that, bringing only this aspect, that this amount is not being
If
paid.
your lordship will, I mean, allow me, lord, the allegation is not that I am not paying the MGR. What he wants is that in the past transaction that had taken place, there was some reduction of the MGR, and he wants me to now pay. He wants the government to recover the area of MGR. If your lordship will kindly see the prayer, his prayer at page 56.
Now, this is against Sumit.
Yes.
You are
So,
scheming.
yes,
You are
as far as I am concerned, my lord, I have been paying the MGR as per the agreement.
Mr. Dotto, how can this court segregate the petition, the PIL, or strike you off?
No, my lord, if your lordship will kindly come to page 58, his relief is that because of the COVID situation, the government had reduced the MGR for a certain period of time. He wants that the government should recover that now.
No. He is asking for that period where Sumit did not go ahead and did not do there was a period of the agreement during which they did not go for any draw, but they were liable to pay as per him. Isn't that, Mr. Mazumdar?
My lordship may turn to page 60, pair G. What your lordship is saying is there.
Mr. Dotto, how do I segregate? How do I segregate
Your lordship is
that?
absolutely correct.
That's why, my lord, in my IA, I have said that in the present form, the PIL cannot be entertained. Because he has...
PIL cannot be entertained on the question of digital thing. Fantastic.
Also on his locus, my lord. Also on his locus. Because
No,
what he
locus,
is
why
asking...
not?
My lord,
He is a person, he is a citizen of India. He is a citizen of India. Would he not be worried about the state, the state not getting the reserve? They are not in this state.
No, that is not his case, my lord. His case is not that state is not getting the MGR as per the agreement. His case is that in the past state had reduced it, and therefore that reduction should be waived, and that reduction should be recovered now. That is his prayer. His prayer is not that because of the current agreement, my lord, I am not paying the MGR.
My friend may kindly see prayer G at page 60. My lord is referring to that. My lord is referring to recovery of 5 crore 70 lakh, which the state government
Yes,
is not
that is pertaining to a period during the COVID, during the 2019 to 20.
Yes, they are not
But
how can he ask for in the PIL
Mr.
now?
Doctor, tell us one thing. How is it possible that without getting the response from the state on affidavit, how are they doing it as regards this amount? This court should be satisfied.
No,
This amount.
my
After
lord,
all, it is public money. Yes,
No, my lord,
not at
that-
his instance, it's a different thing. Not at his instance. But can't this court then also look into this as a PIL to that effect?
my
Only to
lord,
that
the
extent?
period, my lord, if your lordship will kindly see the page 59, the prayer G, that is relating to a period 2019 to 2020. Now those agreements have become obsolete by now.
But
The fresh
recovery-
tenders have been
No,
quoted
no,
and
that is why he is
fresh,
coming. That is why he is coming. Then look here, this is the state of affairs. The state government is giving so much of relaxation to these people.
No,
They are the
now-
blue-eyed people. They don't want the money of the state government to be there. They are
Now,
so.
even
Why
in-
is the state
even-
government so benevolent in spite of the fact that the roads are not in a proper condition?
Now, my lord, in that scenario also, my lord, my submission will be, since it's a contractual dispute, it's a matter between the state and the contracting party. There is something like privity of contract. How a third party like this petitioner can come and have a say, because it's a commercial considered. The decisions are based on commercial considerations, and state has, because of certain circumstances prevailing at that point of time, state has decided to waive off a particular part of the MGR, and that was not particular to me alone, my lord. It was given, this benefit was given to all concerned.
572.
This was given to all concerned, and there was a writ petition filed telling this. And when this writ petition was pending, that is writ petition 5 of 2022, subsequently when the government had changed the decision, my lord, the writ petition was withdrawn. How that particular issue can again be raised in the PIL now? I have in my IA also, my lord, I have
Parties are
mentioned this.
different, Mr. Datta. The council may be the same. The parties are different.
My lord, here, my lord, everyone knows who is where. that is the situation, my lord. In my IA, my lord, paragraph 10, my lord, I have said that was a writ petition file. And here, if your lordship will kindly look at the credential of the gentleman who is coming up as the petitioner, my lord. Lord, he discloses nothing. Well, Lord, my verbal instruction, my lord, I have not placed that on record. My verbal instruction is that he is a pawn shop holder.
Huh?
And he is a pawn shop holder in the city of Aizawl. This gentleman who has filed the writ petition, that is my, of course, my lord, my verbal instruction. And he says that he has done so many things. Where are the disclosure?
It shows, but there is no bona fide intention and he has no political interest.
No, my
That
lord.
shows.
There is certainly interest, because if your lordship allows me, lord, I can show the
Mr.
chain.
Datta, have you seen his letterhead?
Yes,
Seen his
my lord,
letterhead? He can't be a
my lord,
pawn shop holder.
my lord, your lordship will kindly see his signatures appearing in certain pages. Your lordship can make out. My lord, my yesterday, last evening, my lord, my briefing council had
No,
shown me.
Mr. Datta.
If your lordship will kindly see his
Yes, in
signatures appearing on different pages.
2001, the signature was not so good. But in 2024, he has improved on his signature.
No, in the current year only, my lord.
No, I think you are referring to this portion of his ear. Kindly see page 69, there is no signature.
Yes.
Then if you kindly see this one, there, yes, kindly see page 76.
Yes.
His signature at page 79. See,
There,
this is,
yes.
yes, so this is of 2024. And then compare it with the signature which is there to the principal secretary. I think it is made more legible at page 90.
93 and 105.
90, it is more legible there.
90 is more legible. 93 and 105, your lordship may kindly see also. And there is no disclosure
That is
in
why
the
I'm
writ
saying
petition.
earlier it was more legible. 2022 it was more legible. But now here, I think with his and the letterheads and all, now he has put his signature in a different manner.
And to
Minor-
RTI,
minor-
in the entire transaction, my lord,
My lord, slightly on the lighter vein, signature keeps on changing with age. And I cannot put my signature the way I used to put up 15 years ago. It's a fact, my lord.
Mr. Mujumdar, kindly don't say from 26 to 28 you have changed your signature. Not
No,
you,
I'm
not saying that.
I'm talking about myself, my lord.
No, not
And-
for you. I'm saying about your client. From
My
26 and 28, they have changed the signature. Anyways, Mr. Mujumdar, what to do? You don't have a case.
My lord.
Locus.
My lord, if this may, as your lordship, my lord indicated, my
My
lord,
lord,
if it is closed, he may have some liberty somewhere.
My lord,
We are in
my
the
lord,
lottery.
lordship
We
will
are
give
in
you
the
liberty
lottery
and approach the
business.
central government.
Let's, it's a lottery business. You deposit an amount of 5 crores, let the state use it for its infrastructure.
My
And
lord.
tomorrow you win the case, very well, the state will pay you without interest.
State will pay in terms of making good road condition, building,
Yes,
etc.
and then also you will have the satisfaction
My
that
lord.
at your cost, the states have built roads. What do you say, state government?
Your Lordship, again, my answer at this point would just be limited to the maintainability and whether it should be a PIL at all. That is my only submission at this point, Your Lordship.
Subject to what your lordship say, my suggestion will be, my lordship will give me liberty with further details when I approve the central government as the lordship suggesting. And then if I don't get any relief, I'll come back to your lordships again. Email.
Who is appearing for the unions? Respond number 7. You are appearing? Okay. What is your stand?
My lord,
You can ask the person.
we are, as per this petition itself, my lord, I'm not yet received any instruction. Union of India MHA is only the authority who issued that notification only, my lord. That should be followed by the state, my lord.
Mr. Mozum, the question of granting you a liberty does not arise.
Once your lordship is.
If I give you a liberty,
My
against
lord.
question of local, I am just putting a stamp of authority on,
My lord may,
on your
my lord
locus.
may, my lord may do it this way that I am praying for
But you can't
opportunity
withdraw.
or liberty to
No,
approve
no,
the
you
central
can't
government.
withdraw a PIL also. Problem arises there.
But I am praying for. I am praying for a liberty to approach the central government. Your lordship may make mention of my submission.
You are,
Your lordship may make a mention of my submission that I wish to approach the central government with all my grievances, and if I am not satisfied, I may revert back to your lordship once
that
again.
I can't. No reverting back, I can't give it because that will be stamping an authority, giving you the locus. Later, you want to go instead of that, without touching on his IA, you say that okay, we want to approach taking into account the. Where is that document you were just referring in the morning, just now?
Yes. Yes. Parliament.
Some case, ministry of.
Yes, in the parliament panel, the question and answer.
Has your junior has any such document out here? Nobody has it. You have it?
We do not have presently,
You have not filed anything.
In fact, we have prepared a reply, detailed reply to the
You have prepared a
IA
reply.
filed
Have
by
you
them.
given the reply to your council, local council here?
No, we could not file it.
It has not been filed, but we are filing it today, my lord.
It is to be
Does he have a copy of it?
Copy, yes, my lord. Copy,
yes.
He
With a
says
copy
your
of-
local council categorically says that no such copy is being given. So here, the best part is this: the person
Madam.
who is the Mizoram person,
My
he has no knowledge. Neither his lawyer has the knowledge.
No, we are yet,
My lords.
But
we are,
persons
we
who
are
is
yet
in
to file, my
Guwahati, they
lord.
have the knowledge.
We are yet to file, my lord.
What is this?
Yet to file only.
It is a 5
No, you-
case.
My lords, in the spirit of my lords supporting the petitioner, my lords, we've received copies of this document.
We have got
So,
it.
my lords, we may.
Ah.
See, the respondent has it, not the petitioner.
আমার মাননি নাই ঠিক আছে
Ah, this is it. This is of 2022.
My lord, 2022, 2nd of August 2022.
Your Lordship, the state has not received the copy.
Because, my lord, we have not yet filed the same.
You don't have a copy of this.
No,
We will be serving it today, but since, my lord,
You
since
don't
we
have
have
a
not filed
copy
it
with you
today,
in your hand.
unfortunately, we do not have it with us right now.
Heard Mr. D. Mujumdar, the learned senior counsel, assisted by
S. Biswakarma.
so and so, appearing on behalf of the petitioner. Ms. So and so appears on behalf of the state of Mizoram. Ms. So and so appears on behalf of the Union of India. And Mr. S. Dotto, the learned senior counsel, assisted by so and so
P.
appears on
Sengupta.
behalf of the respondent number 8. Mr. D. Mujumdar, upon hearing the matter at length and taking into account the stand taken by the Ministry of Home Affairs, by the Ministry of Home Affairs, the learned senior counsel, Mr. D. Mujumdar, appearing on behalf of the petitioner, submits that the petitioner ought to have approached the Ministry of Home Affairs directly instead of the state authorities. He therefore submitted that as the public interest litigation was filed without proper representation to the Ministry of Home Affairs of the Union of India, the petitioner may be given the liberty, the instant public interest litigation be closed, giving so that the petitioner may approach the Ministry of Home Affairs. This we have given an anxious consideration to the respective submissions and taking into account that it is a requirement of law that for entertaining a public interest litigation or seeking a writ in the nature of mandamus, it is required that the petitioner approaches the authorities by authority, and the authorities having not taken into consideration the grievance, this court closes the instant public interest litigation. Liberty, however, is given to the petitioner to approach the Ministry of Home Affairs. This court have, however, not decided on this court. Accordingly, the instant public interest litigation stands closed. Before parting, we would like to make it clear that this court have not expressed an opinion as regards the locus of the petitioner.
Much obliged.
DP Auckland.
Much obliged, Your Lordship.
My lords, if you may interject, my lords, some of the private respondents are, my lords, we are
Whoever
representing.
it is, give your names.
Grateful, my lords.
properly.
Obliged.
We'll put it in bold letters.
Item number 6.
Yes,
Yes, Lordship, I'm
you
for
are
the state
the
respondent.
new amicus.
The junior of the amicus, my lord. My senior is on leave. As per the last court's order, the state is required to submit their affidavit.
Yes, Lordship, if
Which area
Your
is
Lordship-
this?
I'm sorry.
Which area is this? It's near the
The
city
area,
hospital.
Chaltang Road, my lord.
City hospital.
No,
Chanmari.
Chanmari, Chaltang Road.
So
Okay, the
if
state has
Lordship-
not filed the affidavit.
Yes, Lordship, if another 2 days' time may be given, it's under preparation in the affidavit. So if I'll be filing it within 2 days, Lordship.
Let's put this matter tomorrow. You hear
I have to
Justice
file
Sailu
an
is not
affidavit,
taking up,
yes,
na?
specific,
Okay.
yes.
Okay, that's
I'll be filing it by tomorrow and,
no, it's okay. Let's have it on Friday then.
yes, Lordship.
List this matter again on Friday. In the meantime, the state respondent.
My lord, if I may interject, my lord, because my senior, the leading...
Mr. Counsel, you are an amicus.
No, my senior is the amicus, my lord.
Whoever it
He's
is,
on leave.
if you don't assist, you see the duty of an amicus is a different thing. Amicus
My lord.
here or not, it is not the question. We
My
have
lord.
taken, this is the matter taken suo moto, taking into account that the amicus would help the authority, the court.
Yes, my lord.
Here we are concerned about the parking and the traffic problem of Mysore.
My lord.
You are a local for Mysore.
Yes,
Are
my
you?
lord. Yes, my lord, I
So
am.
you can also very well assist. We don't need any laws for this.
Yes, my lord.
We only need what is the best way by which the traffic problem can be eased out. We don't require a senior for that.
Yes, my lord.
List this matter again on Friday. Date to deliver. In the meantime, the state respondents shall file the affidavit as directed by the order dated 6/9/2024. Without fail.
Item number 7.
May it please your lordship, my lord, in this case I would seek your lordship's indulgence, a little accommodation, my lord, because matter had come suddenly and I am here, the briefing council is away. So little bit dislocation on my part, my lord. If your lordship kindly grants me some time, Monday I'll be there, my lord, I'll do it.
What is this matter about?
Well, as far as I can remember, my lord, it's a matter where the land acquisition compensations were sought, some awards were passed, and without going for execution of the award, my lord, the writ petitions were filed instead in the High Court. And the writ petition has been allowed, and while allowing the writ petition, my lord, certain amounts have been directed to be paid by us in respect of areas of land which we did not acquire at all.
No. First of all, did the award, here the award was passed.
Award was passed.
Did you challenge the award?
No.
Then?
The award was not challenged, my lord, but
If you have
they
not,
did not put
if you have not challenged the award, then how does it say?
No, they also did not put the award into execution. Now,
How can you put the award into execution? Tell me.
no, my lord, apart from that, my lord,
First of all, an award passed by the DC. The award is being passed by the collector.
collector.
Can it be put to execution anywhere? Tell me.
My lord, I am not with my lord, the brief is not with me, my lord. I am just submitting from my memory, my lord. If I remember correctly, my lord, it was the award was passed.
No, Mr. Dutta, I am also yet to open the file also. But I am asking you, you are a senior counsel. If an
lord.
award is passed by the collector, can this award be put to execution anywhere? No.
No, perhaps, my lord, this award was not by the collector but by the court. I am not sure, my lord. I am not sure, my
It
lord,
has to be
because
only by a reference court.
yes, most probably by a reference court.
If it is by
in
a
the-
reference court, then they can go for execution.
Yes, and my lord, there is a part of in the honorable single judge's order, my lord. There is a part of compensation directed to be paid in respect of certain areas of land which we did not acquire at all.
That is another aspect. But the question, if it is there in the award, the question doesn't arise. Let us see one thing. Show cause as to why the return shall not be entitled to payment of compensation and further to call for the record as to why it should not be directed to him. Okay. No, they did not go anywhere. That is the biggest problem. See, Mr. Dutta,
Well, there was a batch of writ petitions filed on this, my lord. My lord, maybe I am missing out somewhere. Let me do it, my lord. I'll be there on 28th, your lordship may hear.
28,
28, Monday.
28. But how is the writ petition filed? Who is appearing for the
I'm
respondent?
appearing for the private respondents, my lord.
For all the private respondents.
For the private respondents.
Fantastic. Be ready. On 28, we'll dispose it of. Mr.
My lord.
Doctor is coming.
Obliging.
Item number 8 and 9.
28, 2024, on which date an attempt shall be made to dispose. Read the piece. Yes, what is this?
Please, Your Lordship, my lord. If Your Lordship may kindly see the order dated 5/9, passed on 5th September.
What is this? What is the challenge? So, please hold weeks time to say whether sufficient vacancies are available. Yes, the State Council was asked to obtain
My
instructions.
lord, I'm furnishing the documents when they provided that.
You are the State Council?
No, my lord, I'm providing the documents when it was stated that there is clear-cut vacancy.
No, where is the State Council?
Yes, sir, my lord. Annexure B, my lord.
What is this agreement?
It's between the parties, my lord.
You have agreed?
Yes, my lord.
Compromised?
Yes, my lord.
Matter over?
If the impugn judgment is modified to some extent,
Then you file it by way of an affidavit?
I'll do that.
Both the parties? You are paying for the state?
I'm for the respondent, Your Worship, sole respondent.
Writ
Private.
petitioner. He's the writ petitioner.
Yeah.
You are the writ petitioner?
Yes, yes.
Here the question was for accommodating the writ petitioner as well as the appellant number 4.
Yes. It appears there are enough vacancies now.
They have vacancy. And who is paying for the state?
I'm appearing for the state, Lordship. We have also filed an appeal. State has
Who?
filed an
State A?
Yes.
State has filed an appeal. Where is it?
It's the WA number 5 of 2000. It's item number
9.
Item number 9.
Item number?
9.
Oh, here, State of Mizoram. Now, what is the present status?
The status is that, Lordship, there's enough vacancy, sufficient vacancy is there to accommodate both the private respondents and the writ petitioners.
Writ petitioner.
So, writ petitioner. Yes.
So, you are going to accommodate both?
Yes, to some, Lordship,
What
in
was the
the-
direction being passed by the learned single judge? Let's see. Where's
The direction is-
the judgment?
My lord, which writ appeals are you referring?
Where's the judgment?
After the index, my lord, on the writ appeal, in the memo of appeal after the index.
Where is the judgment?
Just after the index in writ appeal 1 of 2024.
You are the, Mr. Malhotra,
Yes.
you are the, appellant, petitioner.
Yes.
And you had challenged the appointment of 6/7 to 9, 6 to 9.
Yes, Your Honor. Para 12 is important, Your Honor. 12 and 13. Ini looks like they put them. Saya rare lagi. Tapi dulu pun sebut apa?
So private respondents, everything was set aside. And
Yes,
there was
my
a
lord.
directive to convene a fresh departmental promotion to fill up the 4 posts after condoning the age of the petitioner here. Process shall be carried out as
Last.
okay. So this is the direction.
Yep, the
Now, what has happened in the meantime?
Para 13, last sentence, Your Worship.
Last order.
There's an observation and liberty
Of a
is
chief.
granted. Last sentence. The DPC will be at liberty.
Huh?
The DPC will be at liberty to accommodate the petitioner and all the private respondents.
If there are sufficient posts, and if not, the principle of last come first go
Yes, my lord.
shall be followed.
Now, subsequent to the passing the impugned judgment order, my lord, there arose another vacancy, meaning thereby there is sufficient post to accommodate all the
So
parties.
now there
here.
are 5 posts.
Yes, my lord. Yes, my lord.
Now, have you filed an affidavit with the government?
Yes, Lordship, we have filed an affidavit in the writ petition.
No, here.
Here we are the writ appellant.
You have filed another.
They have not
appeal,
yet filed, my lord.
No, you have to bring on record your stand that
Yes, Lordship.
we are now having 5, 4 were the respondents and 1 is the petitioner, and we are going to accommodate them. Unless you bring on record that stand by way of an affidavit, on the basis of an agreement between him and him, nothing can happen. Because after all, it is a government thing. You have to come up with an affidavit categorically stating that now we are having 5 posts, and as per the directions of the single judge, we are duly complying with it, and we are going to hold it. Without, however, we'll pass, if you file an affidavit, we'll pass an order that this will be only for this purpose, this will be done, and they will be duly accommodated. No, unless you file an affidavit, on the basis of these agreements cannot happen. Will it?
My lord, in this flat B, if I may draw your lord's kind attention, this is the instruction given by the department to the government advocate indicating that there is one clear-cut vacant post of LDC.
No, Mr. Counsel.
I understand your
you
point, my lord.
appreciate it. Kindly appreciate one thing. If they don't file an affidavit stating in the area that we are having vacancies of 5 posts minimum, the question does not arise of an agreement between you and him. This is no business. There is a direction passed by the single judge. It is yet to be interfered with by the division bench. We are not going to interfere with the direction passed by the single judge to that effect. The single judge said that accommodate these 5 persons, and if there are only 4 vacancies, the last one has to go. So that's it. They have only 4 vacancies, there are 5 persons. So the petitioner would be accommodated and 3 of the other respondents would be done, 1 will go. Now, if you say there are 5, it is for the government to say that yes, we are having 5 vacancies and we are going to accommodate them by bringing as per the matter instead. This is how you bring the closure to the proceedings. Not an agreement between you and Mr. Malhotra.
Yes, Lordship, I'll be filing my affidavit, since I have just received an instruction with regards to that also, that there is a vacant post. I have received an.
Why don't you just file an affidavit? We'll finish it off on Friday.
Yes.
Just file an affidavit to the effect that these we are presently having 5 posts, and as per the direction passed by the learner signatures, we are going to finish it. We'll duly convene the DPC and do it. Because the DPC is required to do it for the purpose of seeing certain requirements. Because you have a manner in which it is to be done. Because this court did not direct appointment of them or regularization. In view of the Uma Devi judgment, this court cannot direct. What this court has directed is you look into it. And while doing it, has to go in this manner. So you just say that we are going to comply with the judgments of the single judge as we are having now 5. So we'll have it on Friday.
Yes.
Discuss matters, both the matters on Friday. So in the meantime, the status shall be, is given the liberty to bring on record their stand by way of an affidavit. In as much as per the instructions by as per the instructions so submitted by Ms. So-and-so, the learned state counsel, there are 5 vacancies, but on the basis of which both the petitioner as well as the private respondents can be accommodated.
I'm obliged.
Orders, item number 10.
Yes, Mr. Counsel, keep this. It will be required.
May it please your lordships?
What is this?
My lord, the matter is a condonation of delay. However, my lord, I am in a bit of a pickle. Last court date, I was allowed to file the amended cost list,
How
deleting
much
the,
delay?
yes,
How much is the delay?
2,345 days, my lord.
2,300.
Yes, my
What
lord.
has happened? The other side has appeared.
That is what I am coming to, my lord. So there are several respondents who have died, retired, joined other jobs. So as per the last court order dated 5/9/2024 in IA, my lord, I was allowed to file an amended cost title deleting the names of the private respondents, those I have mentioned, my lord. However, although I have filed my cost title, it has come to my knowledge that the deleting those respondents have caused a bit of a problem in the petition as well as the IA, my lord, because the serial numbers have now changed. So I have mentioned several names of several numbers of the respondents in my petition as well as my IA, wherein now that it has moved up to 23 from 35. At the first time of filing, there were 35 respondents, my lord. So now
Respondents?
35. Now I have submitted a new course title, which has now come to respondents 23, my lord. So this has totally changed the outcome, the nature of my petition, my lord, because I have made
Now you have 23.
Yes, my lord.
Earlier it was?
35.
So now it has reduced.
Yes, my lord, because some have retired, some have passed on, some have quit their jobs, like that. That is why I was directed to change the course title, my lord. So by changing the serial number, moving forward with the serial number, have totally changed the nature of my petition, my lord.
That it is the problem.
My lord, if I may.
No, I see a trend out here that there is a mutual agreement between officials. How can there be a mutual agreement with an official? You cannot have an agreement with the officials. This is where is the reason you are having an agreement with your counterparts, by which they say that okay, we are happy with you being at this serial. Now later on, they've changed it.
Yes,
The
my lord.
government has changed it. Obviously, the government has changed it. How can you have any mutual agreement? It's the government who has to say that. Like in the earlier case, which I was saying, it cannot be an agreement between you, between the private officials or the government officials. It has to be. Yeah. The same agreements. Taken care of and the was present or the data You are challenging which judgment? Passed in 125.
Yes, my lord. 125 of
2016.
2016. Yes, my lord. Part
Now,
121 to 2018.
Then you initially filed a writ appeal.
Yes, my lord. At the initial stage, my lord, there were 35 respondents.
Honey, that is understood.
Yes.
Against the judgment passed in 125 of
2016, my lord.
Did you file a writ appeal?
Yes, yes, my lord. But
Where?
it was in the 2000
Annexure 3A. Where's 3A?
page number 67, my lord.
Where?
No, sorry. Main petition.
Where is that order? The writ appeal?
My lord, it is
Petition
at page
15 of
78.
2020. Huh?
Page 78 of the IA, my lord.
Page?
78 of the IA.
78. IA filed where?
Of my IA, my lord.
In writ appeal?
Yes, my lord.
Principal seat it was filed.
Yes, my lord. It was withdrawn, my lord.
Against the judgment passed in?
To 125 of 2016, my lord.
Money should be disposed of to the IA. Page 99.
Yes,
Is
my
the
lord.
order.
Page 99 is the order.
But madam, wouldn't it be a separate cause of action? There was a direction passed by the single judge.
Yes, my lord.
Pursuant to the single judge direction, you have agreed to something and authorities say that, okay, we are going to do that. You filed a writ appeal initially with a condonation of delay.
My
There is a
lord.
condonation of delay,
Yes, that was a condemnation of delay. However,
which was condonation of delay application was closed on your withdrawal,
yes, my lord.
saying that the authorities say that your grievances will be taken care of.
Yes, my lord.
Now, after this, the grievances were not taken care of.
No, my lord.
So, under such circumstances, how can you now again file a writ appeal?
Against the 125 of 2016, my lord. Okay. It is because the WPC 125 of 2016 has decided our fate, my lord, regarding our seniority, my lord. So it has affected us all the way till date. And there was also another case, WPC
Because
126.
if this is being given,
Yes, my lord.
there will be never an end to anything.
This, my lord, order in 125 of 2016 has
Because
been
this order
again
was
used.
passed in 2021.
Yes, my lord.
Okay.
21 to 2000.
2021.
Yes, my lord.
Now, pursuant thereto, when did they change their attitude?
Again, another case was filed, my lord. Based on the mutual agreement, it was also agreed by all the parties, batches of the diet lectures that they have decided to do this and that. However, the seniority was issued by the respondent state government, my lord. Therein, the seniority was again affected and not made as per the mutual agreement, to which the petitioners in WPC 127 of 2021 were aggrieved against the respondents of the who are the promotees in 2008, my lord. So again, naturally, they had to come to the court, wherein the court in 127 of 2021 passed judgment on 15/9/2023, again basing the judgment upon this 125 of 2016, my lord. So it has
That is 15 of 2024.
yes, my lord, the 2023, my lord.
Huh?
15/9/2023.
15/9/2023.
Yes, my lord. Basing upon the judgment of
There is
WPC.
earlier another writ petition file which was withdrawn 15 of 2024.
That was my writ petition, my lord, against the seniority passed in pursuance to the judgment and order passed in 15/9/2023,
So
my
you
lord.
withdrew.
Yes, I was
Some correction
asked to
required
withdraw.
in respect to the prayer portion. She therefore. Now this is the reason why you have sought for withdrawal.
Yes, my lord. There
Then
again.
you filed 23.
Yes, my lord. 23 of
What is the order
24
passed in 23?
to file an appeal, appropriate appeal.
That she may be allowed to withdraw with liberty to file an appropriate appeal.
Yes, my lord. So, upon the direction of the honorable court, my lord, I had to file my appeal against.
You only submitted you want to withdraw. The court did not say that you cannot. We come back at 2.
Order item number 10.
May it pleases your lordship.
Madam, one thing,
Yes, my lord.
the learned single judge in writ petition 125 of 2016,
My lord.
in its judgment dated, what is the date of the
21 to
judgment?
2018.
21/12/2018. That's the judgment.
Yes, my lord. 21 to 2018.
Directed this thing to be completed within a period of 3 months.
My lord.
Then you filed a writ appeal.
Yeah, my lord.
There was a delay.
Yes, my lord.
And because of that delay, thereafter you withdrew the writ appeal, the condonation application.
Yes, my lord.
And you were therefore asked to, you may proceed, and thereafter if you wanted, you can very well again come back.
Yes, my lord.
But coming back, don't you think has to be within a reasonable time?
Yes, my lord. But my lord, today, without going into the merits, if my prayer is that if I may be allowed to amend the cause title, my lord, that's
Why?
my, because I have been directed and allowed to delete some of the names of
That
the.
is okay.
Yes, and
But if we
delete.
dismiss it, where is the requirement of amending?
But my lord, no notice have been issued to the respondents.
Not necessary. We have to be satisfied.
But my lord, there is no inordinate delay on our part, and there is no
There's
lethargy.
absolutely a delay.
There-
You were supposed
Yes,
to
my lord.
you made your submission, which was made
Mm.
before the court on 4/1/2021.
Yes, my lord.
You filed this IA when? You filed this IA
23rd of July
in
2024.
2019. This IA you filed it in 2019, page 78.
My lord.
So you must have filed the accompanying writ appeal in the year 2019.
Yes, my lord.
Then after 2 years,
Yes, my lord.
you say, submits that he has instructions not to press the interlocutor as the respondent have assured the applicant that the interest of the applicants will be taken care of. It is only an assurance,
Yes, my
nothing in written.
Yes, my lord.
And therefore, in view of the prayer stands closed as not pressed, however, liberty is given to the applicant to approach his court again if grievances not unredressed.
My lord.
Page 99.
Yes, my lord. That was issued on 4/1/2021. So what happens?
4/1/2021.
Yes, my lord.
Then,
So what happens in?
then it has to be filed within a particular reasonable
My
time.
lord, yes, it was filed. However, during the period of filing, during the period of the judgment and order passed on 21 to 2018 to the order 4/1/2021, what happens was that, of course, we were, there was, if I am not mistaken, but I cannot say for sure, there was a or delay of 60 to 90 days for the condonation as well, the first writ appeal, which was allowed.
That's okay.
Yes.
That's I'm
So
not on that.
in between, while the writ appeal was pending before the principal bench, mutual agreement was signed between all the parties, including.
Mutual agreement cannot be, you see, first and foremost, one has to understand that it is a judgment of the court.
Mm.
The state cannot hold that the judgment of the court to be in, shall not, the state, it cannot be such that the state tomorrow say, oh, we are not going to follow the judgment of the court.
So then, my lord, so the order was
Mutual
passed
agreement
on.
between you and the private parties.
No, but
or
that was, my
has
lord.
no relevance
Yes,
unless there was anything signed
Yes.
And if that is signed, then it is a contempt.
On 4/1/2021, the order for allowing the withdrawal was passed. Then, based on the mutual agreement signed, the state government, the respondents issued an inter-seniority list, my lord.
Where?
It is at page number 100, notification dated 26 July 2021. If I may read paragraph number 2, my lords. This provisional inter-seniority is refixed based on the mutual agreement made and signed by the incumbents of lecturers of diet on 31/8/2020 and on withdrawal of the WPC number 125 of 2016 dated 21/2/2018, Kemhing Tanzawi and 14 others versus excuse me, state of others and
So
80
here,
other-
as per this, it
Yes.
was done as per the mutual agreement.
Yes, my lord. So inter-seniority was issued as per.
When was it changed?
According to this mutual agreement, the direct recruits of 2007 were supposed to be the first in line and followed by the 2008 promotees, then followed by us, my lord, the petitioners. However, according to this notification and not according to the mutual agreement, the promotees of 2008 were placed first in front of the 2007 direct recruits, followed by us. So in being aggrieved.
Then there was another judgment.
Yes, my lord. So being the 2007, the direct recruits who were aggrieved by this mutual agreement, by this seniority list, filed the WPC 127 of 2021, my lord. So it has been affecting our seniority till date. Although we have signed the mutual agreement, the judgment in passed on 15/9/2023 has also reflected that the mutual agreement was repudiated by the petitioners of the said WPC 127 of 2021, my lord.
But you were not a party to 127.
No, my lord. No, my lord.
So why didn't you file an appeal against that?
My lords, there was
You
this.
should have filed an appeal against that.
Yes, my lord.
Or
we-
filed a review against that order. Taking into account that there was a mutual agreement, whatever may be, this is the reason why this has happened.
Yes, my lords, we were in a dilemma or regarding that as well, because the judgment and order passed on 15/9/2023 based the judgment upon this 125 of 2016, my lord. That's why if we do not file an appeal against this 125 of 2016, the 2016 judgment would still stand. So the initial judgment and order has to be challenged first, to the best of my knowledge, my lord.
But have you
Limited
challenged
essence.
against this 127?
No, my lord.
If you have not challenged against 127, then how do you maintain this petition? At the end of the day, this is again going to have an impact.
Yes, my lord. I do understand your concern and your statement, but to the best of my knowledge, limited as it may be, if the judgment and order passed in 2000 and the order 125 of 2016 is revoked, then the
No, this cannot go because this is also a judgment.
Yes, my lord.
Then
So according to the
because
judgment
this
passed,
judgment will hold the field. This
no.
judgment.
So the judgment and the order passed in this instant, writ appeal can be used as a basis for the appeal in the WPC 127 of 2021, my lord.
As per this one, this is at page 131. 131 or 131, yes. This is the new one.
Yes, my lords. This is the latest inter-se seniority.
And how many petitioners are here?
At present, my lord, at present we are 62.
Huh?
Okay, present petitioner. No? Present petitioners, my lords, we are 61 in numbers.
You joined as?
2005, my lord.
Date of joining under the District Resource Center,
Yes, my lords.
2/9/2005.
Yes, my lords.
You were there.
Yes, my lords.
Date of joining as lecturer. Now your seniority is given from when?
So my seniority has been wrongly reflected from 2013, 15/4/2013, my lords.
As a lecturer. This
Yes,
is a
my
different cadre.
No, same cadre as that of the 2007 direct recruits and 2008 promotees, my lord. As per the 2006 amendment, first amendment recruitment rules, we have been placed under the same cadre, my lord.
No, you were this District Resource Center.
Yes, my lord. To clarify, my lord.
Telescope
Yes.
diet.
To clarify, my lord, initially there was an establishment of telescopic diets, which is not a full-fledged diet, under which we were recruited as lecturers, my lord. Telescopic diets in 6 districts of the
This is
Mizoram.
under what cadre?
They did not have any cadre at the time of recruitment, my lord. So in 2006, the recruitment rules was amended, wherein we were placed under the same cadre, common cadre as that of the lecturers of the full-fledged diet, my lord.
No, thereafter another cadre had come.
Yes, thereafter 2007 cadre of lecturers were appointed, my lord.
What cadre is that?
Lecturers of diet, full-fledged diet, my
There
lord.
must be a rule.
Yes, my lord, the
Where is the
recruitment
rule?
rules. At page number 126 of the main petition, my lord, or the main appeal memorandum, my lord.
126.
At the time of our recruitment, my lords.
This was made in 2006.
Yes, my lords.
Mizoram Education and Human Resource Department Group A Recruitment First Amendment Rules.
Yes,
This
my lords.
amendment.
Yes, my lords. The 100, sorry,
Where the
19,
actual rules?
the 1999 recruitment rules is at page 84, my lord.
84.
Yes. So that was the only recruitment rules available at the time of our appointment, my lords.
Now, you were appointed under these rules.
These rules were relaxed, my lords.
Were you appointed in terms with these rules?
Yes, my lords. Yes, my lords.
Show you any of your appointment letters.
As per the it is at page number 109, annexion number 7, my lords. This is
109.
Yes, my lords.
Yeah. You were not in the cadre.
Initially, my lord, yes.
Yeah.
I do not deny that initially we were not
So what is
encadred.
wrong with the judgment?
No, however, my lord, this is on 2005. We were not encadred yet, but in 2006, the recruitment rules was amended, wherein, if I may have your lordship's attention to page 126, paragraph number 2, amendment of columns.
Then,
In the Annexure 1 of the Mizoram Education and Human Resources Department Group A post, Recruitment Rules 1999 for the entries in column 1, 2, 4, and 8 of the following entries shall be substituted, namely, column 1, lecturer, diet, as well as the telescopic diet. That is our encadrement, my lords. Column number
so
2.
you were thereafter, this was the amendment.
Yes, my lord.
When were you brought in? There must be some appointment order separately, because this is under the centrally sponsored scheme.
Yes, my lords.
So once you are there in the centrally sponsored scheme, you do not come within the state cadre. You will come under the state cadre if there is an appointment. When you were appointed in 2013,
2013, my lord, it was only the upgradation of the telescopic diet.
no, therefore in 2013 you must have got an appointment.
No, my lords.
When did you get an appointment
That
properly?
was our appointment letter, my lord.
No, there must be, how were you brought within the fold of the state cadre? Not by way of an amendment. Because this was a centrally sponsored scheme. See, kindly see. Under the centrally sponsored scheme in the scale of so and so plus other allowances. This is something similar to this, what you call this, RSMS, what is the
RMSA.
Shiksha Madhyamik, all these things.
RTI cần thể lưu thông mô copy thì mình còn my lords,
You are 61.
Yes, my lord, 61 in numbers.
But madam, you have no case.
My
Judgment
lords,
passed by the learned single judge is okay.
my lords, if I may have your kind attention to page 227, 227 of the writ petition, my lords.
Huh?
227, page number 227
Of the writ appeal.
of the writ appeal. Yes, my lords.
2 to 7.
So this is the memorandum of understanding signed between the government of India and the government of Mizoram, my lords, regarding the diet.
2 to 7.
Yes, my lords. Page number 227 of the memorandum of appeal.
Yes.
At point 2.2.2, that is the filling up of the post of the diets, my lord. 2.2.2. The first paragraph, 227.
2.2.2. All posts created in pursuance to their already sanctioned which have not been filled up will be filled up within 3 months and a systematic and This happened when? This is for a centrally sponsored scheme.
Yes, my lord. So accordingly, if I may read 2.2.2 and 2.2.3, my lord, filling up of the post of
So
diet.
therefore it is formation of a separate cadre
Yes,
of
my
teachers.
lord.
So
Yes,
you
my
will be a separate cadre.
Yes, my lord.
You do not fall within the state cadre. Now, subsequently in 2013, by upgradation, you have been brought within the fold of the State Department, the state cadre. Now the state is paying.
No, my lord.
The state is would be paying.
No. No, my lords. The fund is still received from the central, my lord, to the best of my knowledge, but I can confirm.
It can't be so. Kindly see.
As has been informed to me by my clients, my lords.
No, it cannot be because here, you see, this is the letter. Where is that particular rule you were saying? This is the state cadre.
The 1999 or the 2006, my lords?
The rule you were referring to? Yes, recruitment rules. Department of Education.
126.
Yes, this is the year, they are here because the Governor of Assam is to make the following rules relating to recruitment of the principal of diet, so and so under the Education and Human Resource Government of Mizoram. So here, if it is under the Government of Mizoram may have to ask money from the central government for whatever may be, they don't have any resources. But the money has to be paid from the coffers of the consolidated fund of the state government. So it cannot be from the central government. You see, that is the difference out there. You look into this judgment, there is an important judgment out there where you will find out that you don't have zero case. No case at all. There is a Supreme Court categorical judgment, I forgot the name of the case. Just 1 minute. I'll give it to you. See the judgment of 2002 10 SEC 656. Got it?
Not yet, my lords.
2002 10 SEC 656.
2002, 10.
656. The short judgment. Come, have you got it? Dhyan Singh. This has also been followed recently in another judgment, Parmeshwar Nanda.
The internet is very slow, Your Lordship. The internet is very slow, Your Lordship.
Huh?
The internet is very slow, Your Lordship. So, We are hotspotting from our mobile phone. It's taking time.
Our question is only, why do we give those people some sleepless nights unnecessarily by issuing this? You see the last portion of that paragraph number 1. There's no paragraph itself. Last paragraph, order, it's an order, last paragraph. The continuance, have you got it? The continuance of like engagement. These people were under the centrally sponsored scheme of adult, what do you call the adult education scheme. You see, the continuance of the engagement of the appellants under the specific scheme cannot be held to be employment under any establishment of the government. Such schemes are taken up for certain contingencies when money for the same is provided either by the central government or at times by some foreign countries. But the employment under such scheme not being a part of the formal cadre of the state government, it is difficult to hold that the period for which an employee rendered service under such scheme can be counted either for the purpose of deciding the pensioner or even for fixing their salary in the scale of pay once they are regularly absorbed. The judgment of the court pursuant to which the appellants were absorbed as against the regular post to the government itself would indicate that the court had taken a compassionate view and not on any right which flowed from past service rendered by the appellant under the scheme in question. We have not been shown any rules or regular which ever confers pensionary benefits to. So therefore, you are different. And not only that, there are 2 division bench judgments of our High Court also following this. This is on the case of this Sarva Shiksha. This is also under the central scheme. Now, what has happened in Nagaland? These people were brought within the fold of the state because they were outside. So they were brought within the fold of the state. So they sought for that they should be given the seniority from the date of their initial appointment, because these posts were created accordingly. Now, the matter came up before the single bench and then came up before the division bench out there. I was presiding, I suppose. So there I have held that nothing doing, it can't be done because of the fact that this is a case of these people were never there within the year. And this very aspect has also been taken care of by another Supreme Court judgment in the case of Parmeshwar Nanda, wherein it says that as to when a person entered into the services. So, that case, why do we give sleepless night to those people by issuing this?
My lord.
Already 13 have already died.
Well, lords, if you may kindly show leniency and if I may be allowed to try my luck in that other division bench, my lords, and if the same judgment goes, then yes, I will agree.
But I have made your friend knowledgeable on that.
No problem, my lord. If I may kindly be allowed to try my luck again, my lords.
Now, what do you want?
My lords, if I may be allowed to amend the cause title without changing the numbers of the serial numbers, my lords, because
No, the fact is, inside there are the problems.
yes, my lords.
So you need to amend it.
If
How do you amend the cause title? You just for example, out of 35, you make it 23.
yes,
Now,
yes,
once it is 23, you have made it. Now, it is not coinciding with the paragraphs which are contents of the
my
petition.
lords, yes, my lords.
So, under such circumstances, don't you have to amend your petition accordingly to make it in consonance with the respondents?
Cause titles, yes, my lords.
Huh?
Yes, I
Why do you
understand.
take so much of pain? Let me dismiss it.
No, my lords. I am trying all the luck I can, my lords. I am trying my best for my clients. That's why, my lords.
You're lucky you are in. You see, many judges can't take it up. Many of them have superannuated or quit the job or died, and therefore she prays for some time to file an amended cause title. Now the question is, if somebody has superannuated, then also he will be entitled to be a party. Because would this seniority affect somebody's pensionary benefits?
My lords, the superannuated.
Somebody has quit a job, it's a different thing, which obviously they have duly taken note of.
Against the superannuated, my lord, we have no complaints.
Then
Against the 2007 and 2008,
your problem is only for this reason.
yes, my lords.
That if you are brought within, shown as brought within the service in the year 2013,
Yes, my lord.
your pensionary benefits will accordingly become less. Isn't your pensionary benefits dependent upon the amount of service you put in?
Yes, my lords. From the time.
Whichever job is a different thing. Okay, madam, we do one thing. I won't say much. Let us have it after 2 weeks.
2 weeks, my lords.
Better, because you don't have a case.
I am deeply obliged.
Because you see, if there is a superannuation,
Yes,
it will impact the pensionary benefits of that person. So you can't remove them.
my lords.
If somebody died, then also it will impact the pensionary benefits. There might be a case of recovery. You can't remove. You have to bring the legal representative. If somebody has otherwise have an impact, because these aspects have, if somebody has quit the job, you have no problem because you will automatically go up.
Oh, true.
But the only issue is whether you should be counted from 2013 or 2005. Not on the basis, because if it is on 2013, then obviously 2005, then obviously you get an additional 12 years of service, which will be counted. But who is going to pay for those period? Because it is the state cannot pay. Anyways, good luck for you. At the request of the learned counsel for the petitioner, matters stands adjourned to be listed after 2 weeks. I hope I am not back again to see this matter. But next time you don't get a chance.
Deeply obliged, my lord.